The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast from the Federal Courts of Appeals. My name is Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. And with me today is Senior Attorney Rob Fromer, also of the Institute for Justice. But more importantly, joining me is a special guest, civil rights attorney in Chicago, Joey Mogul. Joey, welcome to Short Circuit.
Hi, thanks for having me.
Now, Joey, you recently litigated a very bizarre and interesting case with the city of Chicago about criminalizing giving away free food to protesters. And I should say, the reason why we got interested in this case is we at IJ are interested in the rights of people to share food with one another. And so we didn't like the looks of what the city of Chicago was doing. Please tell us what's happened.
Well, I like that you support sharing food with one another. I think it's particularly important in the midst of this COVID pandemic that we share food with as many people as possible. On May 30th of 2020, as the nation experienced and witnessed several uprisings in response to the police murders of George Floyd and Breonna Taylor, as well as Tony McDade and too many other Black people at the hands of police officers, we had a massive protest here in the city of Chicago. Thousands came to downtown Chicago. They were protesting in the streets. And as time wore on, the police department and the city of Chicago tried to shut those protests down. So they ended up imposing a curfew at 9 p.m. that night that they announced publicly at 8:40 p.m. They put bridges up over the Chicago River that prevented people from walking to and from different parts of the downtown area. And they had suspended our CTA, our public transit system in the downtown area, which essentially locked many Black and brown young people downtown with no means of being able to get home that night, particularly to the south and west sides where they live here in Chicago. And so there's an organization here, it's called the Chicago Freedom School. It's a youth organization based on the Freedom Schools in the 60s in the South that provides support and services to young people. They had opened up their doors and they let young people know that the Chicago Freedom School in the South Loop of downtown Chicago was open, available to provide space to people, bathrooms, as well as free food, including takeout pizza, granola bars, and bottled water, as well as, face masks and other, materials people could use to stay safe in the pandemic. And then they had young people come in droves to their office, and young people were tweeting out and using social media that this was a safe space. And at 11 o'clock that night, as the protests were dying down, and the Chicago Police Department called on members of the Business Affairs and Consumer Protection Agency to conduct an investigation of the Chicago Freedom School's premises. And essentially, they then were raided by members of the Business Affairs and Consumer Protection Department of the City of Chicago, as well as Chicago police officers clad in riot gear, and said they needed to investigate the Chicago Freedom School's premises based on allegations that they were housing and feeding protesters, like that was some sort of crime. They didn't have a warrant, and they ended up coming and they inspected and searched the Chicago Freedom School's premises. They took pictures of the premises, including items that they hung on their wall. They could see that they were passing out takeout pizza, granola bars, commercial prepackaged snacks, and bottled water. And they then left them with a cease and desist order saying that they had violated the Chicago Municipal Code because they didn't have a retail food establishment license, essentially a license that restaurants need to prepare and sell food to its customers.
And I'm guessing when you give food out to guests of yours, that license doesn't apply.
That license does not apply if you're not selling food. And that license doesn't apply if you're not preparing food. And that night, they were not preparing or selling any food. They were providing prepackaged, commercially prepared food to individuals who were coming. None of it was prepared on premises. And of course, it was being given out for free. And this is what any youth organization does. You know, this is what churches do. This is what religious organizations do. This is what we do at our offices sometimes, right? I mean, you don't need a retail food establishment license. But what was particularly chilling about this was that they said, and they told them that night, and it was included in the cease and desist order, that if they continued to provide food to people in this manner, hand out takeout pizza, they were going to arrest members of the Chicago Freedom School and fine them $500 to $1,000 every time they do this. So that is essentially shutting down the Chicago Freedom School as an organization that works with youth every day, many of whom have food insecurity issues, who aren't going to come to a day-long program or come seek services if they're not able to eat and they're not able to provide them with food. And so as a result of this, and after hearing this, you know, Sheila, Betty, and I work at the People's Law Office. Sheila works at Northwestern Law School in the Community Justice Clinic. We filed a civil rights complaint in federal court here in the Northern District of Illinois in Chicago on behalf of the Chicago Freedom School, and we sought a preliminary injunction on their behalf, essentially raising that the Chicago Police Department and other city officials violated their First Amendment rights and their Fourth Amendment rights. You know, and essentially arguing that, and I think that this was about chilling the Chicago Freedom School's support of these protesters who were, you know, righteously protesting anti-Black police violence here in the city of Chicago and the nation. And by, you know, coming and illegally searching, raiding, and providing this cease and desist order, they were seeking to chill their First Amendment expressive activity. And so as a result of filing the lawsuit, a week later, we filed the lawsuit, we filed the motion for a preliminary injunction, and a week later, essentially, the city of Chicago agreed to rescind the cease and desist order, I think, which is a tacit acknowledgement that it was completely bogus and fraudulent in the first place, and it should have never been brought. And, you know, we're now working to finalize and resolve and settle the entire case.
Thank you for that, Joey. That's interesting. Why do you think, it sounds like the CPD wanted into the building. Why do you think they looped in the consumer protection people? Why do you think the police just didn't, you know, barge in themselves?
Well, they have what we can understand from Freedom of Information Acts that we, FOIAs that we filed, that there is this new summer division that they've created to do some policing and surveillance of individuals. And the BACP was part of that. And I think that they were hoping to use the BACP along this issue of food lines to somehow provide some legal justification for getting in the building. Otherwise, there's no way that the Chicago Police Department could get in because, like I said, they had no warrant and there was no probable cause that any crime was being committed. So I think they were using this pretextual justification around the passing out of food.
And did BACP, that agency, say that they didn't need a warrant to come into the building because
Yes.
because they were searching for food, that somehow the Fourth Amendment's warrant requirement didn't apply to them?
Right. I mean, there is an understanding under Berger versus United States that if you are a highly regulated business, there may be a lesser standard for conducting a search, particularly where there's health precautions and the rest. And so, but that doesn't mean you don't need a warrant in certain circumstances, even for a highly regulated business. In this case, I think they were arguing, and they were trying to argue, well, you're acting like a food retail establishment, therefore we have a right to come in and inspect your business. But, you know, again, let me be clear. The Chicago Freedom School is a not-for-profit, okay? It is not a restaurant. It is not a commercial business. So these laws that they were applying to them are just inapplicable.
Yeah, and it sounds like no reasonable person, even given the facts and in the confusion that might have been happening at that time, thought that they were actually violating the city ordinances, and that therefore somehow they can shoehorn in as you said, that the Berger test, which allows you to do warrantless inspections of businesses that you actually know are selling food. So it sounds like they almost had 3 layers of BS inferences in order to enter the building.
And I think what's troubling too is after filing these FOIA requests, we find out that the BACP, the Business Affairs and Consumer Protection, just routinely goes and inspects, which I can understand. They maybe want to inspect various restaurants or various commercial establishments to make sure that they are complying with health codes. But then they routinely just issue these cease and desist orders. But in this case, they made fraudulent allegations in the cease and desist order that the Chicago Freedom School was both preparing and selling food, which it was not. And to then provide them with the cease and desist order. So I definitely have concerns about what is their basis providing a cease and desist order. And just so you know, the Chicago Freedom School is an amazing organization here in the city of Chicago that does really beautiful and righteous work with young people, educating them, doing political education, telling them about their rights, helping train leaders to help organize social movements. And we have so many leaders in the city of Chicago who are alumni of the Chicago Freedom School. It's beautiful. And they are a beloved member of our community. And so 300 people ended up writing the city of Chicago, condemning them for this raid and demanding that they pull the cease and desist order. Before we filed the lawsuit, I wrote the Business Affairs and Consumer Protection Department demanding that they rescind the cease and desist order. And their response is, we just issue these cease and desist orders all the time. And if your clients aren't violating it, then it's just fine. They can go about their business, without understanding that what they did in the first instance was wrong, without acknowledging that what they did was fraudulent and should have never, it's one thing to inspect the business, but to then provide them the cease and desist order was just outrageous.
That reminds me of arguments we get in some of our cases about standing, where a cease and desist order has been issued, and the government will basically say, well, that's it. I mean, you actually haven't been prosecuted with any of this. So what you have no worry, and you have no reason to come to court.
Right. And I think you routinely ruin it, depending on what the violation of the cease and desist order is. You have, I felt very strong that we would be awarded this preliminary injunction because there was, actual injury here, and the future likelihood of injury was very strong, right? Which is what we needed to get the preliminary injunction. So I assume you win on that most of the time in your cases, right?
We do, but it does sometimes take some educating of certain judges who need to be more engaged with these issues. Well, Joey, that you may not know it, but Rob actually was involved in a long fight with the city of Chicago about some of its food ordinances regarding food trucks. So, Rob, in a moment, let's turn to the case you're going to be talking about in the Fourth Circuit. But first, could you give me some comments on what the city did to the Freedom School regarding its food laws surprises you at all from what you know with the city of Chicago and food, or if this is more par for the course?
Unfortunately, I'd say it's par for the course, and it shows the danger of doctrines like the Berger Doctrine and its expansion across a lot of industries. Back in 2012, I actually sued the city of Chicago over its food truck laws, and one of the things I sued them about was the fact that they were requiring food trucks to carry GPS devices. So the question of whether that was permissible under the Fourth Amendment went directly to this exact issue that we've been talking about, this case called Berger versus New York. And what the court said there is that in very dangerous, highly regulated industries, we can allow for warrantless inspections. But what has happened, and the Supreme Court's been very clear that that's supposed to be a very, very narrow category of ultra hazardous activities. And what has happened over time, though, is that the lower courts have expanded it to pretty much every business under the sun. And we actually filed a cert petition. We showed how there are 30 different industries that have been declared by the lower courts to be closely regulated, including people like taxidermists. And what it allows is it allows these people to go in without a warrant. So once you give a government that kind of tool, it's a powerful tool, and they're going to use it anytime they have a problem. Like in this situation, I think that BACP was probably front and center, partially because they knew that they would be able. The CPD knew that they could never get in without a warrant, but BACP could use this idea. Oh, maybe your retail food establishment and burger to bust right through, and that shows the danger with these kinds of doctrines to how they can prevent people from really being secure in their property, and also to be able to protest, like just like this Freedom School and the people there were doing.
So, Rob, speaking of dangerous situations, some judges in the Fourth Circuit disagreed about what exactly that was one night in a certain neighborhood a few years ago.
Oh boy, I tell you, this was a bit of a wild case, and it's a 99-page opinion with 4 concurrences and 2 dissents, and it all comes out from a very, very brief instance. So one night in Richmond, some police officers are patrolling, and they hear some shots fired a few blocks away, and so it's random gunfire. So they turn around. They get in their cars. They think it's 2 or 3 blocks away. They zoom over there. In the meanwhile, there's some contemporaneous 911 calls come in. Same thing, just hear random gunshots. They get there to the building, and there's a field behind the building, which is where they think the gunshots came from. But they don't see anybody with a gun. They don't see anybody on the ground shot. They just see people sort of either standing or walking about just normally. And then instead of just walking up to people and saying, hey, did you hear any gunshots? What happened? What they started doing is approaching people, shining a light in their face. And next thing you know, just ordering them to stop. Like, you have to stop and talk to us. And not just that, we are going to even though we don't have any suspicion about you in particular, none of these people, they had nothing to tie them to the gunshots. They just started making them show whether they had any weapons on them or anything like that, lifting up their shirts. And they approached this man named Curry. He's one of the dozen people out there. And he says, oh no, the guy who, he actually says to the police, the guy who shot went that way, who was firing the shots went that way. And I'm actually here looking for my nephew. The police, undeterred, do the same thing, tell him to stop, tell him to show his shirt, lift up his shirt. There's a scuffle. And next thing you know, he has a weapon on him that they discover. And then they try to charge him with felon in possession under federal law. And the district court said, no, they asked to suppress the evidence, and the district court agreed, saying, no, you don't get to just walk up to people you have no suspicion of doing anything wrong and order them to show, to expose themselves. You can't stop them. A panel of the Fourth Circuit in a 2-1 opinion disagreed and said this was perfectly fine under the exigent circumstances exception. And then it went en banc to the full Fourth Circuit, and we ended up with a 9-6 opinion with, like I said, 4 concurrences, 2 dissents, and a lot of heat between the judges. For a very small incident, it turned into a major constitutional issue.
But how did they ultimately, how did the en banc panel resolve it?
Well, the en banc panel, by, like I said, 9-6, they said that the en banc court said that the panel was wrong, the district court was right, that they had no basis to stop Curry under a doctrine called Terry, which allows the police to stop individuals when they believe they have a reasonable suspicion of imminent criminal activity. And they can do a protective frisk of the person to make sure they don't have a weapon. But again, they didn't know anything about Curry here. They didn't have any reason to suspect Curry. And so they tried to lean on the exigent circumstances. The idea there was by reading the dissent, you would hear them say, this was an active shooter situation. And they would continually point out that one officer testified that maybe one person was favoring one of their arms. And they thought, well, maybe he was shot. I mean, they subsequently talked to him and they didn't get him any medical attention, so it doesn't seem particularly likely. But the dissent keeps harping on this. Like, there was potentially a shooting victim and there were shots fired and we don't know what's going on. And there's a lot of hand-wringing by the dissent that the majority's decision saying that you can't just stop people without any suspicion, they said this ruling is going to essentially unleash chaos upon largely like the inner city and areas where there are already, as we've been talking about, historical issues with policing.
And Rob, it seems like I didn't exactly add up all the concurrences, dissents on this point, but much of what's going on there is this dissent by Judge Wilkinson that talks about predictive policing and how this undercuts predictive policing. And the concurrences are basically saying that that's resting on a bunch of pseudoscience, which leads the reader to believe that there's a heck of a lot more to come down the pike on figuring out what all this means.
This gets at a lot of I've done a lot of cases where I represent protesters, right? And this comes up a lot, particularly when we have mass arrest situations, where they believe that there's some sort of mass probable cause that they can arrest because people are at the scene of a crime, which is, in my case, is the protest. And so I think it's really important, this case, I haven't read this case, but it's like, again, I think it's very important that, the Fourth Amendment requires individual particularized probable cause, or in this case, reasonable suspicion under Terry. And this, to be honest, sounds like a classic violation of Ibarra versus Illinois, which is a U.S. Supreme Court case, where essentially they had evidence that maybe one person in the bar may have had drugs. So they went and searched all 10 people in a bar to see who had the drugs. And they said that's a violation. This case, too, sounds like just they didn't have individual particularized reasonable suspicion to search this individual, so he shouldn't have been searched. So I'm glad they came out this way. But predictive policing seems to completely undermine this concept of individual particularized justification, right?
I agree in one extent and then disagree in another. Like the predictive policing, it's interesting because a lot of these opinions are about the predictive policing, and that really seems to me that's mostly about like where do you put officers generally, like in what precinct, what block. But the constitutional issue here is not so much like where the officers were at the beginning, it's what they did once they got to the scene. And that's the problem, is that once they got to the scene, they didn't engage in voluntary consensual encounters. They didn't act as members of the community, just trying to enlist the support of people. Instead, they started to use their authority to just stop people, to force them to expose themselves with no suspicion whatsoever. So predictive policing, it's interesting because, yeah, you're right. There's two concurrences about it. There's a dissent about predictive policing. But ultimately, at the end of the day, it's about the officer's actions on the ground, because that's where the Fourth Amendment truly gets violated, when the agent of the government orders you to expose yourself without any suspicion whatsoever. That's just unconstitutional.
Right. And it's something we see that happens in the cities all the time, right? I mean, look at the Floyd versus New York case in New York, where there was just all these massive stops and frisks of young Black and brown people in the city of Chicago on a routine basis. And let's be clear, a frisk isn't just often a pat down. It is also often having to lift up your clothes, exposing yourself, because they don't limit it to just patting your clothes down. They often go inside your pockets or inside your clothes to search for things. So, I agree with you. It's an interesting case. I am now going to go read it, but and I'm sorry I haven't beforehand, but I do think that this is something that we see routine violations of all the time.
Rob, do you see further life to this case? And is there a split that might be involved, a petition coming, cert petition?
I don't know if there's a split. They don't reference a split anywhere. They don't acknowledge a split anywhere in the opinion. The majority does, however, point out that There's very little case law about there's a decent amount of case law about exigent circumstances with regard to like entering a building. Like I'm chasing a suspect, or there's someone who I know is lying on the verge of death inside. Like that's pretty common. But the majority opinion says like we're not really sure how we're supposed to deal with exigent circumstances in the context of seizing and stopping people. And there's very little case law on this. I think that plus the 9-6 opinion, 9-6 decision split here could potentially mean that there's a cert petition. I think it's something that would benefit from further explanation from the court, from the Supreme Court, in lines of like Carpenter, Riley, but we'll see what happens.
Well, Joey, before we go, how can people learn more about your practice and the cases you're working on in Chicago with the Freedom School and with others?
I mean, right now I'm working with Sheila Betty. If people want to find out more, you can look me up. I'm at the People's Law Office. We're on the web. We're on Facebook. And you can look up Sheila Betty at the Community Justice and Civil Rights Clinic at Northwestern Law School. Unfortunately, we've seen a lot of police violence in response to these protests against police violence, which I think is not is sort of a given. But so we'll be continuing to try to support the protesters and fight back against this police violence with the courts to the extent we can, understanding there's severe limitations to it.
Well, we'll keep our eyes on the Windy City and elsewhere. And I'm reminding you to stay engaged, and we'll see you all next time.